Proceed.
We've heard all the testimony, and the prosecutor has closed his proofs, and we are asking that the court will dismiss this case, making a motion for directed verdict because they have not met their burden, and there was no probable cause for it. They have not met their burden beyond a reasonable doubt in this matter.
All right, Mr. Majorano.
Thank you, Your Honor. I would cite to the Supreme Court opinion of People versus Hampton. And that states that in order to grant a motion for directed verdict, the court must find that the evidence favored and most light favored to the prosecution, that a rational trier of fact could not find the essential elements of the crime or proven beyond a reasonable doubt. People submit that we haven't done that in a light most favorable to the prosecution. We ask you to deny the motion.
Looking at the evidence in the light most favorable to the non-moving party, which is the prosecution in this case, I do find a sufficient factual basis to allow the trier of fact to determine the ultimate issue in this matter. And therefore, I would deny the motion for directed verdict. Anything else, Ms. Askew?
No, Your Honor, thank you.
All right, Mr. Majorano.
No, Your Honor.
And you've had a chance to look at proposed jury instructions and everyone's okay with those?
Yes, Your Honor.
Yes, Your Honor.
All right, so Ms. Askew, when we bring the jury back in, I'll say you may proceed, you can rest, and then we'll go into closing arguments, okay?
Yes, thank you, Judge.
All right. You may be seated. Morning, ladies and gentlemen. Ms. Askew, you may proceed.
Good morning. We rest at this time. We don't have.
All right. Mr. Majorati, you may begin your closing remarks.
Thank you, Your Honor.
Yes. Okay. Mr. Snow, can we get the other monitor turned on? We're all set. Proceed.
Good morning again, everyone. Thank you again for sitting through this trial and for your careful attention. We've heard a fair amount of witness testimony, seen a fair amount of evidence. Now I'm going to summarize those facts and apply it to the law, Judge Jackson has instructed you. At the end of this presentation, I'm confident that you will find beyond reasonable doubt that Arthur Woods is guilty of carrying a concealed weapon, felon in possession of a firearm, felony firearm, because he possessed a revolver while in the commission of that felony and was previously guilty of a felony conviction. Now, to prove this case, I first must prove beyond a reasonable doubt venue. And that is that on or about July 14, 2020, within Saginaw County, this crime occurred, or these crimes occurred. That is not in dispute. Each of the officers in this case have testified that they responded to a 911 call on July 14, 2020 at the Birch Park Apartments in the city of Saginaw, county of Saginaw, where Arthur Woods' revolver was found. There has been absolutely no evidence to dispute this fact. So right away, we can check off the first bullet. Now, the defendant is charged with carrying a concealed weapon, which means I must prove beyond a reasonable doubt Arthur Woods knowingly carried a pistol, that this pistol was concealed on or about the person of Arthur Woods. I also have to prove the charge of felon in possession of a firearm, which means I must prove beyond a reasonable doubt that Arthur Woods knowingly possessed a firearm in this state and that Arthur Woods had previously been convicted of a felony. Now, the defense has already stipulated the fact that the defendant has previously been convicted of a felony. This is not a dispute. So right away, we can again check off that second bullet point. Pointing to the wrong one, that one. And then finally, I also have to prove felony firearm, which means I must prove beyond a reasonable doubt that Arthur Woods committed the crime of felon in possessing a firearm, and at the time committed that crime of possessing a felony firearm, he carried or possessed a firearm, in this case, the revolver. So ultimately, the question as I see it in this case is this: did Arthur Woods carry or have possession of that revolver that was found on the tire of the SUV where he was standing and making suspicious furtive movements when the police arrived? My answer to you today is absolutely yes. To answer that question, you need to look at what possession is. You'll see that on the right here. Possession is Arthur Woods had actual physical control of the pistol, as I do this, or Arthur Woods knew of the location, had reasonable access to it. Now, in this case, we've heard testimony from Troopers Miller and Kemmer and Officer Babinski. Each of them testified they went to the Birch Park Apartments in response to a 911 call. We heard that call. You heard the caller describe a group of people in the parking lot in the front of building 3032. They were fighting and they had guns. Minutes later, Troopers Miller and Kemmer entered the complex on foot, and they went directly to that building 3032 to find a group of people, including Arthur Woods, right where the 911 caller said they would be. Now, as the officers moved in, Troopers Miller and Kemmer testified that they saw Arthur Woods look at the police cars, walk around that SUV, make suspicious movements, having pockets, his waistband, making movements towards that tire, as was demonstrated by Trooper Kemmer. You heard the officers testify that Arthur Woods was told multiple times not to move, but he didn't. Why would any reasonable person do that? Why would any reasonable person walk away from police officers ordering them to stop? Why would any reasonable person attempt to hide themselves from view by going behind the SUV, turning their body away from the police, and making movements towards that tire? The answer is simple. Arthur Woods had something to hide from the police. He had something he knew he wasn't supposed to have, and he was trying to get rid of it. He had a gun. He had this gun, same size as a cell phone, easy to conceal in a hoodie, pocket, waistband, pants pocket. That is what Arthur Woods had. We know this because the police found that gun on the tire where Arthur Woods was standing. Why would Arthur Woods want to get rid of that gun? Remember, he was a convicted felon. He was not eligible to have that gun. In this way, there is evidence beyond a reasonable doubt that Arthur Woods carried that revolver and it was concealed on or about his person. He had this revolver before the police arrived, and he tried to get rid of it once they arrived. In the same way, we can answer the question involving felon in possession and felony firearm. If defendant carried that revolver as he was walking away from the police so he could hide it on that tire, he clearly had possession. He had direct physical control. Even more, as he placed that gun on the tire, he still had possession. Again, he knew its location. He had reasonable access to it. Now, the defense is going to try to find some invisible shred of reasonable doubt. They may come up here and try to argue that Arthur Woods was just out for a walk that night. At 3:30 in the morning, at the Birch Park Apartments, known as a high crime area? Really? That he had nothing to do with that revolver. They might also try to argue to you that there's no evidence that puts the revolver in Arthur Woods' hands or on his person. There's no fingerprints, no DNA. But consider this. There is absolutely no evidence to support the idea that Arthur Woods was just innocently out for a walk that night. Even if that were somehow true, that doesn't mean that he didn't have the revolver. Now, we know from the testimony of the witness, expert Gary Ginther, that it's not uncommon for no fingerprints to be found on guns. Just because there's no fingerprints doesn't mean that Arthur Woods never touched that gun. Is it reasonable for Arthur Woods' revolver to have belonged to someone else? Like Kendrell Buford, Travion Buford, or Jessica Swain? No. We heard testimony that none of those individuals were near that tire. Additionally, Travion Buford and Jessica Swain had firearms or firearm accessories, the magazine, of their own. And those things were not compatible with the revolver that Arthur Woods had. Now, is it reasonable for someone to just leave a loaded gun on a tire after a fight with the other people in the parking lot that just occurred? No. There's been no evidence to prove that that's what happened. Is it reasonable for someone to walk away from the police as they're ordering them to stop, turn their body away, grab their pockets, their waistband, as they're moving from that tire where the gun was found? No. It is, in fact, unreasonable to assume that any of these things, because they do not line up with the evidence. Arthur Woods was in a group of people reported to have guns. When the police came, he walked away, started to check himself, made movements to that tire. No one else was around that tire. Again, remember Trooper Kemmer and his demonstration. Also remember the fact that Officer Babinski testified that the gun had the handle facing outward. Someone had just put it there. It was Arthur Woods' gun, ladies and gentlemen. I ask you to find the defendant, Arthur Woods, guilty of carrying a concealed weapon, felon in possession of a firearm, and felony firearm. Thank you.
Ms. Askey, you may give your closing remarks.
Thank you. Do I have permission to move about the courtroom, Your Honor?
Yes.
Thank you. Good morning. So we've gone through this entire trial together. And I want to remind you all of what I said in the beginning, when I said that prosecutor wasn't going to show you any DNA evidence. They weren't going to show you any fingerprints, and they weren't going to show you anyone who's actually seen Arthur with the weapon. And ladies and gentlemen, sure enough, that's what we got here today. No one could see Arthur with the weapon. No one has any DNA, and there are no fingerprints anywhere to be found. I also want to remind you that in the beginning, the opening of what the prosecutor stated that this guy's case was about guns, stolen guns. The testimony stated that there were no stolen guns here. In fact, Trooper Miller stated in his own testimony that the guns weren't even stolen. The prosecutor failed to meet their burden today, just as the officers failed to properly investigate this matter. Trooper Miller stated that there were 4 to 5 subjects standing there and that they came in on foot, that the first 911 call was made at 2:30 a.m., that they got there, 2:45 a.m., I apologize. They got there around 3:30 a.m., almost an hour later, and they want you all to believe that everyone was still standing there. They said that there were 4 to 5 people that were there, 4 to 5 people. I played the body cam. It was much more than 4 to 5 people that were outside at that time. Trooper Miller also stated that when he came, he didn't see any guns on Arthur personally, and that he doesn't even know how the gun got there. No one saw Arthur with the gun. Sergeant Kimmer stated that he got there within minutes, which is amazing because they were partners that night, both state troopers working that night. But somehow he got there within minutes, even though they got there at the same time. And he gave us a over-the-top explanation of how Arthur bladed his body and did these movements. But that wasn't in his own police report. And he previously testified at the preliminary exam, and he never stated that that was what Arthur was doing. It was that he turned his body away. And I explained in my opening that he was searching for his cell phone and his keys. And I even asked Sergeant Kimmer if that would have been an important detail to make at that time, an important detail that there was all this movement to put in his police report. He stated himself that it would have been. Well, why was it omitted? Officer Babinski arrives on the scene. He is the only one with the body cam, and I play that body cam for you all. He states that when he came, he states that Arthur wasn't in custody, but he was. And in the video, we were able to see how far away Arthur actually was from where the weapon was. And what else did we see? Kendrell Buford, the man in the gray hoodie. He's apprehended right behind the car, right very close to where that weapon was. And speaking of this weapon, there was DNA, there was fingerprints done on it. They didn't find anything on it. We had a fancy expert here, Gary Ginther, who couldn't tell us that they found anything that would tie Arthur to that weapon. So we don't have any physical evidence. We don't have any eyewitnesses here that stated that they saw Arthur with the weapon. But the prosecutor wants you to believe that they met their burden beyond a reasonable doubt here. I just want to ask a few questions. What if the police had actually questioned everyone that was there, all those people that were there, asked them how long they were there, who else was outside? There was testimony given that there was a fight between Travion Buford's girlfriend and sister. They weren't on scene at that time. In fact, they had been taken away from the scene. Almost an hour had elapsed. One of them could have put the guns there. How do we know that? We don't know because the officers didn't do a proper investigation here. They didn't ask questions of everyone that was there. What if they had actually taken DNA from Arthur? Officer Babinski testified that the gun was placed down like this. Arthur has larger hands than that itty bitty gun that the prosecutor keeps showing you. Obviously something would have gotten on there. Arthur asked to have his DNA taken. They didn't take his DNA. He asked, he said, take my DNA. They didn't take his DNA. Why didn't they do that? Furthermore, why didn't the officers find the person who made the 911 call and ask the person who made the 911 call what everyone looked like who were standing outside? We have no descriptions in these 911 calls. We just have male and female. Are they Black? Are they white? Are they tall? Are they short? We don't know that. Ladies and gentlemen of the jury, that gun could have got there anytime and any way. That wasn't even Arthur's car that weapon was found on. But the prosecutor wants you to believe that my client, beyond a reasonable doubt, possessed that gun and knew it was there. My client emphatically said it wasn't his weapon. He waived his Miranda rights to make a statement and say that that wasn't his weapon. He begged and pleaded, please take my DNA, take whatever you have to. That's not my weapon. They didn't do that. They singled him out because he's a felon. And that's what this really is about today. And ladies and gentlemen of the jury, you all should be enraged that we're here today on that they're trying to bring this case before you with such a lack of evidence. But when you go and deliberate, you can all right this wrong that's occurred. You can deliberate and find that Arthur is not guilty. And Arthur and myself are both entrusting you to make the right decision today and send him home. Thank you all.
Rebuttal, Mr. Majorana.
Thank you. Ladies and gentlemen, there's such a strategy as throwing spaghetti up the wall and hope something sticks. In this situation, we heard a lot about DNA. Well, remember what the officers told you about DNA. It's not the lab's policy to test for DNA in these situations. That is what it is. But use your common sense. 911 call was made, people fighting, people had guns. Now there's discussion about when was the first call made. First call was made at 2:45. But remember, the last call that you heard, the last call that said, oh, they have guns, was at 3:30. 3:30 in the morning. Officers Kemmerer and Miller were in the same car. They told you they arrived within 5 minutes of receiving that call at 3:30. So it doesn't matter. 2:45, people were fighting. So what? At 3:30, people had guns. 5 minutes later, officers were on scene and they found what? Guns. They found a gun on the tire where Arthur Woods was standing. Common sense. Now, it's true, I misspoke about stolen guns, but I did not say this case is about stolen guns. I said it's about illegal guns. It was illegal for Arthur Woods to possess a gun. Why? He's convicted of a felony. He has no right to have a gun. It is illegal. Now, talk a lot of people showed up. That's what happens when police show up in the middle of the night. People come out, what's going on? Why are all these police here? Trooper Kemmerer testified. People came up, showed up, what's going on? Why are people out here? They didn't know who was there before. They didn't know who came later. How could they ask, well, when did you get here? When were you there? People show up out of the woodwork to see what's going on. Now, Ms. Askew has told you about this story of him searching for cell phone and keys. Ask yourself, where is the evidence of that? Did we hear anything in this trial today about searching for cell phone and keys other than the statements of Ms. Askew? No. I remind you that the statements of the lawyers, including myself, is not evidence. It's just an argument. It's just an argument. There is no evidence regarding cell phones and keys. What there is evidence of is that officers came on site. They observed Arthur Woods hanging around this vehicle. When they made their approach, told him to stop, he walks away. That's suspicious. He walks around that SUV to go out of sight. That's suspicious. He turns his body away from the police. That's suspicious. He makes a motion to that tire. Unsurprisingly, a gun is found on that tire. It's common sense. Now, we talk about Arthur being detained by Trooper Kemmerer, and he's trying to take an interview, ask him questions. We saw the video. It was a very poor recording. I couldn't make out hardly anything that was said. Other thing I could make out was that Kemmer was trying to ask questions and he was denying he had the gun. That's it. No explanation for why he was there. No explanation. He was there with the gun, ladies and gentlemen. Now, you've also heard from Trooper Kemmer. He didn't put him under oath. There's no swearing to tell the truth. He asked the questions. He could have been lying. People lie. It happens. Now, what about Travion Buford? As Ms. Askew indicates, we heard testimony from Troopers Miller and Kemmer. Travion Buford was detained at the same time as Arthur Woods. I don't know where this idea came from that he was detained an hour earlier and carted away. Detained at the same time. They're all standing around. And you talk about Officer Babinski's body cam. His body cam depicts the events after what officers or Troopers Miller and Kemmer described to you. We see that on the body cam. You see Arthur Woods getting searched by Trooper Kemmer. You saw Kendrell Bruford getting searched by Trooper Miller. They were already being detained at that point. What happened before that's not on video. It's just not. I ask you just to use your common sense. Think about everything you've heard. Look at the circumstances, and I ask you to make a decision. Find Arthur Woods guilty of the crimes he's charged. Thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If the lawyer says something different about the law, follow what I say. At various times, I've already given you instructions about the law. You must take all my instructions together as a law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you're satisfied by a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond reasonable doubt, you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. Reasonable doubt is just that, a doubt that is reasonable after a carefully considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence, or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to say the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision on the evidence I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide the case based on any evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think the testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Has there been any promises, threats, suggestions, or other influences that have affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the evidence in the case? Sometimes the testimony of different witnesses will not agree. You must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that the witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that will be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. In this case, the lawyers have stipulated to the fact that the defendant was previously convicted of a felony. You've heard testimony from a witness, Gary Ginther, who was giving his opinion as an expert in the field of latent fingerprint analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he gave for his opinion, whether those facts are true. You should also think about the expert's qualifications and whether his opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count 2, the defendant is charged with the crime of carrying a concealed pistol. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that the defendant knowingly carried a pistol. It does not matter why the defendant was carrying a pistol, but to be guilty of this crime, the defendant must have known that he was carrying a pistol. Second, that this pistol was concealed on or about the person of the defendant. Complete invisibility is not required. A pistol is concealed if it cannot easily be seen by those who come into ordinary contact with the defendant. In count 3, the defendant is charged with possession of a firearm after having been convicted of a specified felony. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that the defendant knowingly possessed a firearm in this state. Second, that at that time, the defendant had previously been convicted of a felony. In count 4, the defendant is also charged with the separate crime of possessing a firearm at the time he committed the crime of felon possessing a firearm. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that the defendant committed the crime of felon possessing a firearm, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Second, that at the time the defendant committed that crime, he knowingly carried or possessed a firearm. A pistol is a firearm. Possession does not necessarily mean ownership. Possession means that either the person has actual physical control of the thing, as I do the pen I am now holding, or the person knows the location of the firearm and has reasonable access to it. Possession may be sole where one person alone possesses the firearm. Possession may be joint where 2 or more people share possession. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about July 14th, 2020 in Saginaw County. When you go to the jury room, you'll be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During the deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you discuss the case among yourselves, but ultimately each of you would have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It should duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give an honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my law clerk. Possible penalties should not influence your decision. It's the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my law clerk. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until we return with the unanimous verdict, do not reveal this to anyone outside the jury room. When you go through the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the exhibits that have been admitted, other than the gun, just ask for them. When you go through the jury room, you will be given a written copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as a law you are to follow. The defendant is charged with 3 counts. These are separate crimes and the prosecutor charged that the defendant committed all of them. You must consider each crime separately in light of the evidence in this case. You may find the defendant guilty of all or any of these crimes or not guilty. I've also prepared a verdict form listing the possible verdicts for you. Count 1 charges the defendant with carrying a concealed weapon. Your possible verdicts are not guilty, guilty of carrying a concealed weapon. When you reach a verdict, your foreperson will sign and date the verdict form. Count 3 charges the defendant with possession of a firearm by a felon. Your possible verdicts are not guilty, guilty of possession of a firearm by a felon. Once again, when you reach a verdict, your foreperson will sign and date the verdict form. Count 4 charges the defendant with felony firearm. Your possible verdicts are not guilty, guilty of felony firearm. Once again, when you reach a verdict, the foreperson will sign and date the verdict form. I'd like to see counsel at the bench, please. Ladies and gentlemen, that concludes formal instructions, and at this time, we will reduce the number of jurors who will decide this case. 2 of you will be excused by lot. If your number is called, just please remain seated, right?
Juror number 12. And number 1.
For those who were just excused by lot, I still would ask you not to discuss the case with anyone nor yourselves, because as alternates, if something should develop, you may have to come back and be a part of the deliberation in this jury trial, okay? So still do not discuss the case until a verdict has been reached in this particular matter. All right? I'll ask you to swear the jurors, and those all will stand and be sworn, please.
And raise your right hand. You and each of you do solemnly swear that you will well and truly try to join in the cause now here pending, and unless discharged by the court, a true verdict rendered, and that you will do so solely on the evidence introduced and in accordance with the instructions of the court, so help you God.
All right, swear the law clerk in at this time.
You solemnly swear that you will, to the utmost of your ability, keep the truth, honor, jurors in this trial, private. You will not suffer any communication with them orally or otherwise. That you will not communicate with them orally or otherwise, except by order of the court, or to ask them if they have agreed upon the verdict until they shall be discharged. That you will not, before they render their verdict, communicate with anyone or state of their deliberation, and verdict that they have agreed upon to help you back.
Ladies and gentlemen, at this time, we may go to my law clerk and begin your deliberations. Thank you.
All right, for the verdict.
The record should reflect the jury is not present at this time. After the court had instructed the jury, had counsel approach the bench for any additions, deletions, objections, or corrections to the instructions. Mr. Majorana, I believe you had none.
Correct, Your Honor.
Ms. Askew, I believe you had none.
Correct, Your Honor.
All right, anything else for the record, Mr. Majorana?
None, Your Honor.
Ms. Askew?
No, Your Honor, thank you.
I would ask if you both are not going to be present, that you provide cell phone numbers where our staff can reach you should the jury have any questions or reach a verdict. With regard to the exhibits, you can put them all together. Mr. Majorana will get those into the jury if they request them, all except the gun. They ain't getting that.
I understand.